Welcome, everyone. My name is Sean Randall Travers. The pronouns I use are he, his, and him, and I'm the Executive Director of EDI Learning and Professional Development. Before we begin, I would like to point out the accommodations that are available for this webinar. There's closed captioning available. Just click on the captions in your menu and select Show Captions. We also have ASL interpreters on video today. If you follow the instructions on the slide to change your view setting to side by side, it should work well for you. There's also simultaneous translations in Spanish. Just choose interpretation in the controls and select Español. Simultaneous interpretation is being provided to and from Spanish. Seleccione interpretación en los controles del webinar y seleccione Español. If you did not understand what I just said in Spanish, please use the interpretation feature. To do that, please scroll to the bottom of the Zoom screen where the meeting controls are, and then click on the interpretation icon. It looks like a little world, and select English as your language. If you are joining through Zoom, the mobile app, a cell phone or a tablet or other mobile device, please press the ellipse, those three little dots, and then interpretation, and then choose your language, Español or English. Before we begin, I want to acknowledge the land that we are on today. The UC San Diego community holds great respect for the land and the original people of the area where our campus is located. The university was built on the territory of the Kumeyaay Nation. Today, the Kumeyaay people continue to maintain their political sovereignty and cultural traditions as vital members of the San Diego community. We acknowledge their tremendous contributions to our region and thank them for their stewardship. I want to thank you for joining us today for the second online event in the Tritons Belong series. We have additional events throughout the academic year, both following up from last week's Dialoguing Across Differences webinar with in-person sessions, upcoming sessions on anti-Semitism and Islamophobia, and many more resources that can be found on our webpage. If you'd like to learn more about the Tritons Belong series, the online and the in-person events and the other related resources, visit our webpage, diversity.ucsd.edu/Tritons-belong, which we have also provided in the chat. But there's also the QR code on the screen, so you can capture that as well. UC San Diego has a commitment towards cultivating a sense of belonging and mutual understanding. Chancellor Khosla kicked off the Tritons Belong series, reiterating this commitment. And I want to encourage you to watch and listen to his important words after this webinar is over. A link is in the chat that you can save and watch that later. I would now like to welcome Dr. Becky Pettit, our Vice Chancellor for the Office of Equity, Diversity, and Inclusion. Vice Chancellor Pettit joined UC San Diego in March 2015 and brings over 25 years of progressive administrative experience in equity, diversity, and inclusion work across the higher education community. Prior to UC San Diego, she served as the Associate Vice President and Chief of Staff for the Office of Diversity at Texas A&M University, and served as adjunct faculty in the College of Education and Human Development with scholarship that focused on diversity in higher education, cultural competence, organizational development, and inclusive teaching and learning. VC Pettit provides vision and leadership to and across UC San Diego through the campus-wide strategic plan for inclusive excellence, focused on three key tenets: access and success, climate, and accountability. Her leadership extends to 8 campus resource centers and programs serving the UC San Diego local community. Welcome, Vice Chancellor Pettit.
Thank you, Dr. Travers. And thank you to all of you who are joining us today for another session of our Tritons Belong series. We are so grateful for your continued participation and support of this important initiative as we strive to build understanding and enhance compassion during these challenging times. As you heard Dr. Travers say, last week we held our first session in the series focused on dialoguing across differences in times of conflict. As a reminder, there will be in-person opportunities on campus to learn more and to practice the skills and tools shared in these sessions. Again, that information can be found in the chat. We're also recording today's webinar, and last week's webinar is currently available on our website for your review. Today, we move into the next important topic in our Tritons Belong series, free speech during times of conflict. This topic speaks to a fundamental right in the US and is key to how we at UC San Diego contribute to a better society. Today, we'll hear from a nationally recognized free speech expert on what free speech means in the law and on university campuses. My hope is that you gain a better understanding of your right to free speech, as well as the responsibilities that come with it, and how we can exercise this right while practicing our principles of community. And now it is my pleasure to introduce today's speaker, Emerson Sykes. Emerson is a senior staff attorney with the ACLU's Speech, Privacy, and Technology Project, where he focuses on First Amendment free speech protections. From 2019 to 2020, he was also host of At Liberty, the ACLU's weekly podcast. Prior to joining the ACLU, he was a legal advisor for Africa at the International Center for Not-for-Profit Law, where he provided technical legal assistance to civil society leaders, government officials, law students, and other stakeholders from across Africa to improve the legal framework protecting the freedom of association, assembly, and free expression on a regional and national level. In 2011, Emerson was a senior policy fellow in the Office of a Member of Parliament in Ghana. From 2012 to 2013, he served as Assistant General Counsel to the New York City Council. And here at the University of California, Emerson was a fellow for the UC National Center for Free Speech and Civic Engagement. He developed and piloted a series of practical learning sessions for campus activists to help them learn to address common free speech situations on campus. Emerson holds a JD from the New York University School of Law and a Master of Public Affairs degree from the Princeton School of Public and International Affairs. He earned his undergraduate degree in political science at Stanford University. Welcome, Emerson.
Thank you so much, Vice Chancellor Pettit. It's a pleasure to be with you. Thanks also to Sean Travers for the kind invitation, and to all of you for participating live, and to all of you who might watch this at a later date. It's a great pleasure to be with you. I wish I could be in San Diego. My last campus visit before COVID was actually to UC San Diego. I don't know if you can see it. I'm proudly wearing my UC San Diego pin. It's a campus that's near and dear to my heart, and I'm happy to be back, even if virtually. I'm going to talk a little bit today about some breaking news, and then a little bit about myself, the ACLU, the First Amendment, a current case that I think is a very important one that's currently pending in the federal courts, and then we'll finish up with some practical do's and don'ts for how we approach these issues. So without much further ado, I'll ask to advance to the next slide, and I'll share a little bit of breaking news. I'm speaking with you today, obviously, because we are in a time of conflict. There's literal violent conflict in many parts of the world, and also conflicts of ideas, including on US college campuses. This I don't have to tell you. What we saw, one of the most troubling examples of an unconstitutional response to student activism was in Florida, where the Florida Chancellor threatened to deregister local chapters of Students for Justice in Palestine under the guise that they were somehow linked to supporting terrorism. This we immediately identified as a grave threat to free speech, and particularly student activism on campus. We and a few other partner organizations immediately sued on First Amendment grounds to prohibit the chancellor from deregistering these groups just because he didn't like their political position. And just recently, we actually had our case dismissed, which sounds like bad news. It means that our case will not proceed against the Florida chancellor, but it was dismissed because Florida basically realized that what they were doing was blatantly unconstitutional, and in some ways basically gave indications that they were not going to move forward. The university said that they were not going to deregister the groups, and therefore the judge found that for now there was no imminent threat that the groups were going to be deregistered. But the judge did take pains to note and recognize that threats from officials towards student activists have a chilling effect, and they are a regrettable occurrence, even if he didn't let our particular case move forward. So I share this example just to assure you that we are aware of all the things that are going on campuses, that we are acting on all of these issues, and that they're complicated. And even a win doesn't look like a win. And what does it mean to win in this situation anyway, where it seems like all the options are bad? I want to come back to where some strategies for how we engage in these issues. But first, I want to tell you a little bit about how I came to this work, why I believe so passionately in the power of student activists and in the special thing that is a college campus. So can we go to the next slide? Great, yes. So this is where I'm from. I grew up on a campus. It was not a college campus, it was a prep school campus in Massachusetts. It doesn't look a whole lot like the UCSD campus, but something about the quads and the buildings and the fact that it's a place that is devoted to intellectual endeavor and something that is deep in my bones. It's something that I grew up with and something that I've continued to work on throughout my career. Next slide, please. Another formative experience for me, I think, in terms of student activism and recognizing the power of student activism is around the fight against apartheid in South Africa. Now, I know this is ancient history at this point, but this was fresh history when I was a kid. And the images of students by the thousands taking to the streets to demand justice, to demand freedom, to demand equal protection under the law is an image that is burned deep in my memory. And these folks that are shown in this slide were successful. They overturned the apartheid regime. And this sort of dramatic revolution, a change in the very way that a state operates, was brought about in large part because of student activism. So with this formative experience, I took no further convincing that student activism is an incredibly powerful force for social change. Next slide, please. Fast forwarding a few decades, you'll see a picture here of a group of student activists from around sub-Saharan Africa gathered at the University of Pretoria's Center for Human Rights. You see me with a longer beard and fewer gray hairs in the front. And I share this slide because I think it's an example of coming full circle around the power of student activists. The folks in this picture are master's students from across the continent who are participating in a particular program at the Center for Human Rights at the University of Pretoria. University of Pretoria used to be a bastion of apartheid. This used to be sort of the heartland of the apartheid regime. But nowadays, it is the training ground for Africa's leading human rights activists. They come here, they work together, they learn for a year, sometimes 2 years, and then they go back to their home countries and they do amazing things in indigenous rights, environmental rights, women's rights, disability rights, LGBTQ rights, all sorts of different ways that people can be engaged. These folks go back and do amazing work in their home countries, and they're so well known and so strongly, tightly knit that they're known as the mafia around the continent. They're the Center for Human Rights Mafia. I share this story again to reiterate how these powerful communities of student activists can have dramatic impact on the local international, indeed global level. So let's fast forward again to my work with the ACLU. That's sort of how I became committed to student activism, why I believe in the power of student activism. And I will tell you a little bit about what I do on a day-to-day basis and what the ACLU does to protect and promote activism. Some of you may know that the American Civil Liberties Union was founded a little over 100 years ago. It's one of the oldest civil rights and civil liberties organizations around. We have affiliates in all 50 states, including 3 in California. We have a San Diego affiliate, a Southern California affiliate, and a Northern California affiliate. This provides us with a unique nationwide structure. And we also have a national office. And I work at the national office based out of New York. And within the national office, we have many different teams, the communications team, fundraising, all sorts of teams. But within the legal team, we're divided up into thematic groups. So we have our women's rights team, racial justice, immigrants' rights, all LGBTQ. I'm on our speech, privacy, and technology project, where we deal with First and Fourth Amendment issues. I particularly deal with First Amendment issues around the right to protest, around campus speech, and more broadly around the intersection of free speech and racial justice. Next slide, please. So as you heard, one of the ways that we do this work is that we have been running a series of workshops for student activists around free speech. This was something that was developed with the University of California National Center for Free Speech and Civic Engagement and piloted at UC San Diego just before COVID. Since then, we've run it at several different schools. But the basic idea was to engage with student activists in the absence of a crisis to explain the basic principles around the First Amendment and free speech, and particularly the issues that come up around campus speech, so that you as student leaders and student activists are empowered with the tools to analyze these questions when they inevitably come up. There's always going to be an incident on campus. If it hasn't happened this semester, unfortunately, it will likely happen very soon. So the question is, what are we going to do? How are we going to respond in these times of crisis? And I'll say a little bit about what we think now. So I'll start with, next slide, please, the First Amendment itself. It's short, so I'll go ahead and read it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So we hear a lot about the First Amendment. We hear a lot about First Amendment rights, free speech rights, but I want to take a minute to just break down the language itself. Next slide. The first thing you'll notice is the first word of the First Amendment, which is Congress. Congress shall make no law. This is important because the First Amendment is primarily, exclusively about restraining government power. It doesn't actually say all people or all Americans have freedom of religion, freedom of speech, all these things. No, it says Congress shall make no law. If you compare it to some of the international human rights documents that also protect these similar freedoms of belief and speech, they start with words like anyone or all people. All people have freedom of speech. All people have freedom of belief. Everyone has these rights. Again, the First Amendment does not directly grant any rights to people. It's a constraint on the government's power to regulate private speech. Now, Congress doesn't just mean Congress sitting in Washington, D.C. It means any government entity, including a public university. For the purposes of the First Amendment, UC San Diego and all other public schools and public colleges and universities are the government. They are bound by the First Amendment to refrain from regulating private speech. So let's think about now the poetry of the First Amendment. This is an idea I got from an ACLU legend and NYU law legend, Bert Newborn, who talks about the poetry of the First Amendment and the reasoning behind the 5 freedoms being arranged the way they are. So they are freedom of religion, freedom of speech, freedom of the press, freedom of assembly, and the right to petition the government for redress of grievances. So as Professor Newborn points out, you start with freedom of religion, freedom of belief, the idea that you hold in your head and in your heart. And the idea is that the First Amendment prohibits the government from interfering in those most sacred thoughts, beliefs, and ideas. Next, the First Amendment protects the freedom of speech. So you've had the idea, you hold the belief, and now you're communicating it to those who are around you. And the First Amendment says the government can't interfere in that communication either. Or of the press. So now we're talking about disseminating your ideas, not just for people who are within earshot, but recording it and disseminating it across time and space. So originally, when we think about the printing press, originally the Constitution had in mind the printing press, but now there are all sorts of other means by which we can disseminate ideas electronically, online, or through traditional means. So you've had the idea, you've spoken the idea, you've disseminated the idea, and now the First Amendment says you also have the right to peaceably assemble. That is to physically gather, to show solidarity, and to create energy behind an actual campaign to make change around these ideas. So the freedom of assembly is an extension of this freedom of thought, freedom of speech, freedom of the press. And finally, the 5th step is the right to bring this idea to the very seat of government and demand change in the society, the right to petition the government. So charting these freedoms from an idea to the petitioning the government, we can think of the First Amendment as protecting the journey from an idea to a social movement. And it's with that progressive framing of the First Amendment in mind that I want to talk a little bit about some of the key issues that come up around free speech on college campuses in particular. Next, great, thank you. The first one is something we just mentioned already, which is that there's a big difference under the First Amendment between public and private universities. As I said, public universities are bound by the First Amendment as government entities, while private universities are not. That being said, in California, private universities are bound by something called Leonard's Law, which more or less applies the First Amendment even to private universities, like Stanford or others. And even outside of California, even in the absence of something like Leonard's Law, many private universities adopt their own free speech policies that are at least as protective as the First Amendment itself. So while it's true that the First Amendment only applies to public universities, there are many ways in which free speech principles and academic freedom principles apply to private universities. The second point I want to highlight is that the rules differ between college and K-12. So in the K-12 context, we have cases like Tinker from 1969, which said that students cannot be punished for wearing black armbands in protest of the Vietnam War because this type of silent protest was not disruptive to the school environment. Fast forward to 2021, we had another landmark case litigated by my colleagues at the ACLU called Mahanoy, also known as the F. Cheer case, which was about a student who had sent an explicitly worded Snapchat about school, complaining about school, but not in any way threatening the school environment. And this young person was disciplined for having sent this Snapchat on the weekend, off campus, on their own time. And what the Supreme Court held was, no, the schools cannot punish speech that is off campus, that is outside of school hours, and that does not impact the school community. If, for instance, there were some bullying or some other threats that were happening off campus during the weekend that directly related to the school environment, then maybe the school could intervene. But on their own time, in the weekend, off campus, students do have their free speech rights fully intact. So within K-12, the framework is basically, are you causing a disruption? In college, the rules are different. We have cases going back decades like Sweezy, which talk about the fact that without academic freedom and protection of free speech in colleges and universities, our civilization will stagnate and die. Literally, this is what the Supreme Court says. We can go into some of these quotes a little bit later, but there is a special protection for academic freedom and for free speech on college campuses, far beyond what we see in K-12, and arguably beyond what we see in almost any other context. The last point is that college students have it really rough because of this. As you know, the campus is where you live, it's where you eat, it's where you study. It might also be where you have a campus job. It might be also where you socialize, where you hang out with your friends. And all of this happens in a context with especially strong protections for free speech. So you, as campus residents, are forced to be confronted with ideas with which you might virulently disagree on your way to breakfast or on your way to class, in a way that folks not living on campus are not necessarily going to see on their way to breakfast within their homes. So I just want to acknowledge and name that there's a reason that we have such strong protections for free speech in colleges, but the implications for college students are quite difficult. Next slide, please. Here I just have a list of some of the common issues. You can keep hitting forward. These will seem familiar, right? Classroom disputes where we involve student or faculty speech. I'll say a little bit more about academic freedom in a moment. Dorms and university housing issues, flyers, how do we deal with bulletin boards? I remember last time I was at UCSD, there was like a free speech wall, and there was some deep conversations about how free should this free speech wall be, and how do we want to handle other public spaces that where people might post signs. I'm sure those debates and conversations are ongoing. Think about protesters and counter protesters, speakers invited by the university or by student clubs or other groups, or speakers who are not invited, who just want to rent space on campus. And then there's always the question of how does the administration respond? I know folks like Sean and VC Pettit have a nearly impossible job in trying to figure out how to be supportive of the student body and the staff and the faculty through these difficult times when people really don't agree, and trying to thread that needle is a really hard thing for administrators. And to be honest, quite often their statements leave a lot to be desired. So that's its own sort of set of issues. And then the last question is around how do we draw lines between what faculty say on the job and what faculty say outside of the job, and when those things might have implications for the campus community itself. Next slide, please. So, sorry, there's too much text on these slides, but as I mentioned earlier, there are these statements from the Supreme Court about academic freedom in particular. I'll just read quickly. To impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of our nation. As I said, they wrote, teachers and students must always remain free to inquire, to study, and to evaluate, to gain new maturity and understanding. Otherwise, our civilization will stagnate and die. 10 years later, they said, our nation is deeply committed to safeguarding academic freedom, which is of transcendent value to all of us, and not merely the teachers concerned. These cases were decided in the context of the Cold War and set a high watermark for protections for academic freedom. Unfortunately, in practice, we have not seen this right to academic freedom spelled out very clearly by the courts. I often call it the cotton candy doctrine, because despite all of this very highfalutin rhetoric, when you actually start trying to figure out what actually is protected by academic freedom, it kind of dissolves in your mouth. So we'll go to the next slide and talk about how we're trying to put a little bit more substance here. Academic freedom, there's a circuit split even on behalf of whom and against whom do you have academic freedom. Institutions have academic freedom from other government entities. That is, the university itself has the freedom to operate free from undue political influence. But there is actually an open question around whether professors themselves have individual rights to academic freedom. Some courts have said no, only institutions have academic freedom, while others have recognized that, of course, individuals themselves have academic freedom. And one of my sort of pet doctrinal areas is hoping to get some recognition for students also having academic freedom interests. We can go to the next step. Next slide. So now I want to talk about the most important current fight around academic freedom, in my not so unbiased opinion. I mentioned that we defend the right to protest, as well as working a lot on campus speech issues. And these things intersected because in 2020, the First Amendment team spent essentially all of our time working to defend protesters, racial justice protesters who were facing police violence, they were facing federal charges, they were facing all sorts of crackdowns on their right to peaceful assembly, because they were trying to show their discomfort with the current state of race relations in the United States. Many people called it a national reckoning around race. It's not a coincidence that soon after this quote unquote national reckoning, we had an anti-racist backlash. And after decades, generations of whitewashed history being taught in our schools, we've seen over the last few decades some significant progress in having a more inclusive and representative curriculum in our schools. There's still a lot of work to be done, but I think it's widely acknowledged that there has been significant progress in telling different kinds of stories as a part of our national narrative in our public schools. But this has not made everybody happy. Former President Trump issued an executive order, 13950, on combating race and sex stereotyping. That's what it was called. It was not actually about combating race and sex stereotyping. It set forth 8 divisive concepts that are not allowed to, that it said were not allowed to be required as a part of training for government employees, contractors, or grantees. So he was basically saying, you're not allowed to teach these ideas as a part of trainings if we have anything to say about it. And it laid out a list of 8 divisive concepts that were prohibited. Some of them are seemingly innocuous, right? Like the first one was that you're not allowed to teach that one race is inherently morally superior to another. No one was actually teaching that. So prohibiting that doesn't really seem like that big a deal. Some of the other divisive concepts, though, were totally nonsensical. The fourth one, which often is the fourth one, it says that it's prohibited to teach that anyone cannot or should not attempt to treat others without respect to race or sex. Again, you're not allowed to teach that anyone cannot or should not attempt to treat others without respect to race or sex. A judge recently said that this achieves the rare triple negative. It just doesn't make sense. So some pieces of these, some of these concepts just don't make sense. Others, though, are very strategically targeted at things that people really are teaching, like saying that you're not allowed to teach that anyone should be treated differently because of historic wrongs, or you're not allowed to treat anyone differently to achieve DEI goals. That was something that was another one that was added later. And so these types of divisive concepts, these prohibitions, have a really specific target on ideas that are actually being taught and are actually being welcomed by students. So Trump's executive order was actually almost immediately blocked by a federal court, where it said that it was vague and that it reaches beyond the government's authority because it regulates contractors' activities even when they're not using government money, right? When the government provides funding, it can say you can only use this money for certain things. But what Trump tried to do with this executive order was say, if you accept any money from the government, You're not allowed to have these types of trainings, even on your own time, even funded by other sources. And this, the court said, was impermissible. So Trump's executive order was blocked by a court. Biden withdrew it in his first, maybe his second day in office. So the executive order is no more. But these 8 divisive concepts went on to live 1,000 lives in state laws, local policies, and related book bans on the school district level. Next slide, please. One of the most notable examples is Florida's Stop Woke Act. And here we have Governor Ron DeSantis saying very explicitly, we want a woke-free state of Florida, announcing the Stop Woke Act. Next slide, please. What was notable about the Stop Woke Act is it applied the 8 prohibited concepts not only to K-12, but also directly to public colleges and universities, as well as private employers. So there's a separate lawsuit about the employers, but we and a few other organizations were alarmed at the idea that the Florida legislature was trying to tell public colleges and universities which ideas could be taught in their classrooms. And this struck us as totally inappropriate for a legislature to do. The law says that the concepts may be discussed, but they must be in a quote objective manner and without endorsement. And we've argued that this is nonsensical in a college context. Many of your teachers have written the textbooks, or they at least assign things that they have written. And the idea that teachers should be able to teach these things objectively and without endorsement is nonsensical, especially if you think about an upper level seminar where someone is teaching about their own research or their own writing. The Stop Woke Act does include some mandatory Black history curricula, but we think that that was included mostly just to make it seem like they weren't doing what they were actually doing. Next slide, please. So we filed suit. We filed a lawsuit in federal court. It's called Purnell. It was originally called Purnell v. Florida Board of Governors. It's now Purnell v. Lamb. And our lead plaintiff is Professor Leroy Purnell, who's a Florida A&M law professor and former dean. FAMU is a historically Black college university in Florida. And Professor Purnell is an actual critical race theory professor. There was a time when there was a lot of talk about critical race theory as sort of a catch-all phrase for things that people didn't like about current society, and a lot of things that were being described as critical race theory are not actually critical race theory. But in this case, what Florida is trying to prevent is the actual teaching of critical race theory in law schools. And so our clients, we can go to the next slide. We have 8 different plaintiffs, 7 professors and 1 student, and we brought 4 different claims, we being the ACLU of Florida, the NAACP Legal Defense Fund, and Ballard Spar. We brought an academic speech claim on behalf of professors who are no longer allowed to teach certain ideas in their classrooms. We brought a right to receive information claim on behalf of students. We brought a vagueness claim because, as we said, some parts of this law are totally indecipherable. And finally, we brought an equal protection claim because we believe that there is a racially discriminatory impact of this law, even though it is facially neutral. Next slide, please. I'm proud to share that we actually had this law blocked. We won our injunction. And so the Stop Woke Act is not currently enforceable against public colleges and universities in Florida. And we are currently waiting for a hearing at the 11th Circuit because the state of Florida has appealed. So while we're waiting for the appeal, the law is still blocked, and we're due to argue the appeal sometime in June. So we'll keep you posted. Before I finish and go to questions, I want to go to the next slide, please. Finish with some helpful do's and don'ts for how we can talk about free speech and the protection of free speech, especially in these challenging times. So I'll start with a few things I don't do when I talk about free speech and things I think are not so helpful, particularly in times of conflict. So the first picture is of the signers of the Constitution with a red dot over those who were slave owners. As you see, that's almost all of them. So one of my key points is we should not protect free speech just because the founders said so. Relying on the infinite wisdom and divine vision of the founding fathers is not a particularly helpful place to start with most student activists. Similarly, arguments around kids these days who don't understand the value of free speech, some idea that at some point there was widespread consensus around what free speech on campus meant. I don't think such a thing ever existed. And to the extent there was consensus, it was consensus around a very narrow demographic. And it was only after a lot more people were allowed to get into the academy that folks started to complain. So I think there was never a golden period of free speech, and students now are as engaged and activated and passionate as ever. So I think any argument that rests in students' lack of familiarity with basic constitutional principles is also a bad place to start. And finally, people talk a lot about the marketplace of ideas. And you see in tiny letters, it says, just how fresh are these insights? And this idea of the marketplace of ideas shows up in Supreme Court rulings, and I will admit sometimes even in my own briefs, but I think it's a relatively unconvincing argument because I don't believe in the inherent wisdom of markets to create justice or equality. Neither do I think that the marketplace of ideas will necessarily inevitably result in truth, justice, and equality because the field is not level to begin with. Now, next slide, please. Here's how I choose to describe free speech and why it's important, and the ideas that I try to hold on to when free speech is challenging. First is I stay rooted in the Universal Declaration of Human Rights, right? If we start with essential human equality, if we start with the fact that we all have equal rights by virtue of being human beings, then I think it's less of a difficult step to say that we all have the right to hold our ideas and to speak our ideas, even if we hold ideas that others don't like. And we all hold ideas that some others don't. So starting with the basic premise of universal human equality. The second key point is around anti-authoritarianism, right? The impulse to fight the power. Student activists, if they have one thing in common across all the different issues they might be fighting for, it's an impulse to fight the power, and that is inherent in the First Amendment. The First Amendment is about constraining the government's authority to regulate private speech because we don't trust the government to regulate speech without squelching those who oppose it. So this fundamental distrust of power is key to why we believe in free speech and why the First Amendment is so important. And the final thing I want to remind us is about if we believe in restorative practices in other contexts, if we are prison abolitionists, if we believe, as Brian Stevenson has said, that people are better than the worst thing that they ever did in their lives, if we are committed to explaining to children what they did wrong rather than just sending them to their room, if we don't want to lock people up forever just for one transgression, if we believe that forgiveness is possible in all these situations, then surely when someone says something offensive, we can also hold in our hearts the idea that they might change. It's not to say that we excuse or ignore things that are offensive, but if we just maintain that same level of compassion and understanding that we have for people who have done horrible, horrendous, violent things, then maybe we should also be able to hold that compassion and patience for folks who say and think things that we think are deplorable. Because as hard as it is to imagine someone switching sides, quote unquote, at this time in these circumstances, we have all changed our minds. We've all changed our minds about difficult things. And if you're not willing to admit it, at least you know people who have changed their minds about big things. So let's remember that part of the reason why we believe in free speech is because we believe in people's capacity to change. So I'll stop there. I really appreciate all of your time and energy.
Thank you so much for your time. Our next events are in April, including a session on Islamophobia and anti-Semitism. You can visit our webpage for more information or use the QR code on the screen. Thank you for attending today to show your commitment to learning and growing with us to contribute to a positive campus climate. We hope you can join us for one of our in-person sessions in the spring quarter. Have a wonderful day. Take care.